Greetings everyone, it's me again, I'm back, and this time I want to comment on a piece of, to me, very surprising but very pleasantly surprising news that we got late last week. I'm sure many of you have heard by now that U.S. Attorney General Eric Holder announced, perhaps as a parting shot before he leaves office, that as a matter of a new policy that he's announced, there will be federal authorities will no longer be able to cooperate with state and local law enforcement in a program called equitable sharing, also known as adoption. Basically, this is all about the practice of what's called civil asset forfeiture. This is basically a policy whereby the government can take property from individual private owners and seize it and confiscate it and usually sell it at auction, or seize it if the property is cash itself, and pocket the proceeds for themselves and pad their budgets with it. The rationale behind asset forfeiture is that if the property was acquired through criminal activity or was used in order to commit a crime, then you don't own it anymore, essentially. You don't have a right to own it. You forfeit it to the government, and the government can do with it as it pleases. And so the equitable sharing or adoption policy was essentially a policy whereby state and local law enforcement could actually collaborate with federal law enforcement in seizing property, usually property that's thought to be associated with the drug trade in some way, and turn it over to federal authorities and let federal authorities seize it. And the two levels of law enforcement, federal and state or local, would be able to essentially whack up the proceeds of the sale of those properties at auction. Now, I'm not going to bore you all with all the sordid details of how civil asset forfeiture works in practice. I used to intern at the Institute for Justice, which is a libertarian public interest law firm headquartered in Arlington, Virginia, just across the river from me. And they have done a great deal of very good work on this very subject, and they've been one of the premier organizations at large in the country fighting against asset forfeiture abuse on a daily basis. They litigate against it, they organize against it, campaign against it, they engage in activism efforts against it, and they do their damnedest to raise public awareness about the problem. They have actually published a very detailed and yet very readable report on asset forfeiture called Policing for Profit. It was published 5 years ago in 2010, and you can actually find it and get a digital copy online for free from IJ's website if you just go to their website at www.ij.org. If you go on there and look under publications, or if you just search the title Policing for Profit, the report will come up and you can click on it, download it, and read it at your leisure. And that will tell you a great deal of what you need to know about just how corrupt a practice civil asset forfeiture is. There are a lot of other sources you can also consult on that subject. The Washington Post, the New York Times, and a number of other journalistic outlets have done a lot of really incisive investigative reporting on this subject as well within the past, I would say, 6 months to a year. That's when this problem really began to attract a lot of attention outside of libertarian movement circles. So if you Google asset forfeiture, you will find a great deal of information on the subject. I especially recommend, in addition to the work that IJ has done on the subject, I recommend the writings of Radley Balco at the Washington Post. He's done a lot of great work on just, problems with law enforcement abuse in general, and particularly the militarization of law enforcement in American society over the past several decades. He has had done a lot of really good reporting on the problems associated with asset forfeiture as well. So I definitely recommend his writing, as well as the writings of an acquaintance of mine who I believe works for IJ. His name is Nick Sibilla, and he has published a few articles in Forbes.com and on BuzzFeed that also pertained to the problem of asset forfeiture. So these are all sources you can consult to learn more about the practice. I will tell you a little bit about how it works. There are two categories of asset forfeiture. There's asset forfeiture in the civil realm, which I think is really problematic, for reasons I'll explain to you shortly. And there's asset forfeiture in the criminal realm. The difference is that criminal asset forfeiture involves the government seizing property that was used to commit a crime or that was acquired through criminal activity after the criminals have actually been found guilty in a criminal court of law, pursuant to all the rules of due process that come with that. You know, the presumption of innocence until guilt is proven. All of the rules of evidence that come with criminal trials. You know, the right to effective assistance of counsel. That sort of thing. Civil asset forfeiture, however, involves the government seizing people's property not after pressing criminal charges against the owners of the property, but by filing lawsuits against the property itself. Okay? Now, sit back for a second and try to chew on that just a little bit. I want you to reflect. I want to see the gears turning in your heads as you contemplate the spectacle of government lawyers filing lawsuits with straight faces, mind you, against inanimate objects. And I'm not kidding or exaggerating here, okay? I'm not distorting the factual record at all. You can look it up for yourselves. You can look up articles on Wikipedia and so on. You will see that these lawsuits, the titles of the lawsuits, involve a government agency versus a piece of property. So, for example, there are federal asset forfeiture lawsuits, civil asset forfeiture lawsuits, entitled, I think one of them that I researched when I was interning at IJ was called The United States versus one 1972 Chevrolet Corvette. I'm not kidding. You can't make this stuff up, okay? This practice involves the government suing inanimate pieces of property, inanimate objects that have no minds of their own, that have no brains, no consciousness, no personality, no free will, no ability to choose to do right or wrong, no ability to decide whether to follow the law or to break it. That's what civil asset forfeiture involves. And because it technically comes in the form of a lawsuit against property rather than the owners of the property per se, because of that, courts have used that as an excuse to water down the due process protections that apply in that context. So whereas if you have criminal charges pressed against you and the government is only allowed to use criminal asset forfeiture against you, it can't take your property unless it proves you guilty in a court of law first. And in order to do that, it has to obey the laws of due process and all the other, and the rules of evidence and all the other rules that, in theory at least, are supposed to make criminal trials fair in this country. But if the government wants your property badly enough, and usually it does, it will resort to civil asset forfeiture because it will have a much easier time taking what is rightfully yours in that context, if it uses that tactic instead of criminal asset forfeiture. One of the major flaws in civil asset forfeiture is that the government the burden of proof that normally applies in criminal trials, whether you are wherein you are presumed innocent until proven guilty, is actually reversed. So if the government files an asset forfeiture lawsuit against your property, some property of yours that it seizes, whether it's in a traffic stop, maybe you were traveling with some cash in your car, the police pull you over, they find the cash, they take it, or whether they want to seize the car itself, they want to seize your house, that happens from time to time. Whatever they seize, as long as they can show probable cause, and we all know how lukewarm a standard that is in a lot of cases, as long as they can show probable cause that, or probability that your property was used to commit a crime or was acquired through criminal activity, then the burden of proof falls on you from there on in. You, the owner of the property, then have to prove that it was not used to commit a crime, that it was not connected to any kind of criminal activity in order to get your property back. And of course, this is a lawsuit, not a criminal trial, and so there's no constitutional requirement that the government provide you with, a public defender, for example, a government lawyer, so that you can afford to fight this lawsuit in court, right? So that's just one other way in which the government has far too easy a time seizing people's property under the rubric of civil asset forfeiture rather than criminal forfeiture. So the presumption of innocence is reversed. The police never have any problem showing probable cause that the property was connected to some kind of criminal activity. So they always end up showing probable causes. The judges pretty much always side with them, and so from there on in, the burden of proof falls on the property owner. In far too many cases, people who can't afford fancy, high-paid lawyers to defend them in these lawsuits are the ones who are most likely to be targeted by law enforcement for asset forfeiture. And so it's middle class and poor people who end up paying through the nose. I've actually met some clients before. Well, one client really, a client of IJ, of the Institute for Justice, while I was interning there. This is in the summer of 2012. This is a gentleman who owned a motel up in Massachusetts, and because the motel had actually been in his family for, I think, a generation or two. Definitely his father owned it. I'm not sure if his grandfather did. He owned it free and clear, so there was no mortgage on it that still needed to be paid. No bank still had any kind of claim on the property. He owned it lock, stock, and barrel. And it was a family business that he planned, if I'm not mistaken, to pass on to for the future generations in his family. Problem was, there were incidents in which people were using drugs in some of the rooms. Now, this gentleman cooperated with local police as much as he possibly could, to the point of actually allowing them to, conduct surveillance of the rooms, and I think even install surveillance cameras on the property in order to combat drug abuse that was going on there. He did everything right. He did everything right. He cooperated fully with local law enforcement. But guess what happened? I think a local representative of either the FBI or the DEA, I forget which, whose job was actually to, go through local newspapers and the like to read up to find out whether any properties in the area had drug-related activity connected with them, found out about the drug abuse that had been going on at this motel, even though the owner had been doing everything in his power to combat it, and actually said, okay, we're going to take that hotel. And the fact that the motel was owned free and clear by this gentleman made it that much juicier a target for the feds, because that way they wouldn't have to worry about dealing with split ownership between him and the bank or anything like that. They would have an easier time just seizing it from him legally. And so, even though he had been cooperating with local law enforcement, the local feds were able to get in touch with local police and collaborate to seize this property from him. Fortunately, the Institute for Justice was able to fight that in court, use what's called the innocent owner defense, whereby if the owner can show that he, did everything he could to stay out of trouble, to stay on a straight and narrow path, and to keep the property out of the hands of, criminals, then in that case, if he could prove that in court, he would get to keep the property. Fortunately, IJ was able to win that case. But so many other cases, so many other plaintiffs or property owners across the country are not so lucky. So it's a really heinous practice, not only in terms of the consequences of it, not only in terms of the way it waters down due process, but also, and not only in terms of the perverse incentives that it gives the police, because it ends up turning into a government racket whereby the police actually end up, as IJ's publication suggests, policing for profit. They end up changing the way they enforce the laws of the land in order to maximize the amount of property that they can seize from people and then sell off at public auction so that they can pocket the proceeds and pad their budgets, use their budgets to buy all kinds of extravagant goods, military equipment. We've seen a lot of concerns about that since last summer with the controversy over police shootings and killings in places like Ferguson, Missouri. This asset forfeiture problem is just another tentacle on that octopus of law enforcement abuse in this country. And it gives the police a perverse incentive, not just to try to make as much money as they can, but to seize that money from the very citizens whom they're supposed to be protecting. I mean, it basically contributes to this predatory practice and mentality on the part of sectors of the government, whereby they view ordinary private citizens not as people whom they are there to serve, but as cash cows who are to be milked as much as possible, so that they can pad their budgets and line their own collective pockets. And it's the cops are in on this racket, prosecutors are in on this racket. I mean, it really is an outrage that this sort of thing has gone on as long as it has. But let me tell you something especially absurd about it. The whole thing is ridiculous from its very inception. If you go back to the history behind asset forfeiture, you'll find that it actually dates back to the ancient world, to antiquity, to the Old Testament, in fact. Now, in the ancient world, you had a concept whereby if a given piece of, a chattel as it's called, a piece of property that can be moved around, like a horse or an ox or an inanimate object like a plow, for example, if that property is involved in some incident that ends up doing damage to someone or injuring someone or breaking the laws of the land in some way, then that property could be seized by the king. And part of the rationale was that the property itself had somehow engaged in actual wrongdoing and needed to be seized by the king so that it could then be put to some more pious purpose. Now that concept found reflection later on in the Middle Ages in English common law. It was a concept called the deodand, which is a thing forfeited, and I'm reading from the Wikipedia article here, a thing forfeited or given to God. Specifically in law, an object or instrument which becomes forfeit because it has caused a person's death. And so the idea was the property, this thing that doesn't have a mind of its own, that can't think for itself, can't make moral choices or decisions, has somehow committed a crime and therefore needs to be put in its place, I suppose, by allowing the government of the day to seize it and to put it to some more noble purpose. You ever heard of anything so ridiculous? I mean, honestly. And this is the basis, the legal and philosophical basis for this practice that American governments, and governments in other countries as well, routinely use to rob people blind. That's the origin of it. The idea that a piece of property can commit a crime and needs to be in some way punished or seized and otherwise, put in its place by the government. Really? That's the basis of this whole practice? I'm sorry, but color me contemptuous. I hold civil asset forfeiture in the utmost contempt. Criminal asset forfeiture I can live with. At least then the government has to prove that you're guilty beyond a reasonable doubt and prove that the property it's trying to seize from you actually was connected to criminal activity. But in the case of civil asset forfeiture, where the rules of due process are watered down so much, and it's so much easier for the government to take what's yours, and what's especially outrageous about it is that in many cases the actual owner of the property didn't do anything wrong with it. Sometimes it's an acquaintance of the property owner. Maybe you lent a friend of yours your car for a couple of hours and they went out and happened to be smoking a joint in it, and so they get stopped by the police and the police seize the car. Even if you go to court and try to tell the judge, look, this is my car, not my friend's. He was the one using drugs in it. I didn't know he was going to do that. If I had known, I wouldn't have lent it to him, blah, 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 blah. You may still not be able to get your car back. And then there are other cases in which the police will seize sums of money from you. And, the ensuing asset forfeiture lawsuits will be named. For example, the United States versus $39,000 cash or some foolishness like that. And, sometimes you'll spend years in court fighting these seizures, and sometimes you'll only get part of the proceeds back. Not the proceeds, the actual, the sums of money. Sometimes you won't get most of it back. So my position is civil asset forfeiture needs to be abolished. Period. Shouldn't exist. It should not exist. If the government is going to seize what's yours, it should have to prove beyond a reasonable doubt that you actually committed a crime with that property or that you acquired the property through criminal activity. It should have to prove that first, and it should have to abide by all those standard rules of due process and rules of evidence and all of the other norms that tie government's hands in normal criminal trials. The government should at least have to live up to that standard before it can take what's yours. Shouldn't be able to take what's yours this easily and under these auspices. And based on this ridiculous theory that dates back to medieval or even ancient superstitions, the government should not, I repeat, not have the power to do that to the very people whom it is sworn to serve and protect. So I think that the next step, the long-term goal towards which we should all be working, is the abolition of civil asset forfeiture. I'm glad that Attorney General Holder took this step. Good on him. It's a lovely parting shot coming from him at the end of his career as Attorney General. props to my man Eric Holder, at least in this particular context. This is the kind of move that we've been waiting to see from the Obama administration for years now. So, kudos to them, kudos to Eric Holder. The problem is this policy is too limited in its scope. It's shot through with exceptions, certain types of property that can still be seized in collaborations between federal and local law enforcement, drugs, guns, things of that nature. And it's also got some exceptions that can risk swallowing the whole rule, because for example, if the feds are collaborating with local law enforcement directly and personally, where the actual federal agents are personally involved in the operations, and in the form of a joint federal, state, or federal local task force, then I think that this new rule won't apply. And so in too many cases, you might see the feds simply adapting to this new policy by, investing more resources in these joint federal, state, or federal local task forces so that they can get around this new rule. So let's not celebrate too much. The rule has its limits, it has its flaws, and it might not end up doing all that much good. But we should use it as a stepping stone to do more. Now, part of the reason why local law enforcement loves to collaborate with the feds in the asset forfeiture realm is that a lot of state governments have already woken up to some degree to the dangers of asset forfeiture in the civil realm. And so they have already passed laws at the state level that limit the ability of police to seize people's property under civil forfeiture regimes. So they collaborate with the feds to do an end run around those restrictive state laws. That's part of the reason why, the Justice Department under Attorney General Holder has felt the need to establish this new rule. So what we really need are, and even with this rule in place, whatever good it does, at the end of the day, a lot of states, a lot of asset forfeiture abuse is still going to go on in many states, at the state level, at the local level. So what we need to do is encourage and lobby governments at the federal, state, and local levels to abolish civil asset forfeiture. Now, my understanding is that last spring, Minnesota actually passed a law to curb asset forfeiture abuse by actually preventing the government from using asset forfeiture unless it gets a criminal conviction first. So basically, the idea is that I'm not sure how effective this has been, or how genuinely the law actually abolishes asset forfeiture, but from what I can tell, that's the idea behind it. The idea is the government should only be able to forfeit your property if it gets a criminal conviction first, or if it gets the equivalent of a criminal conviction, such as if the owner pleads guilty to a crime or turns state's evidence or something like that. So that's really the kind of reform we need. We need to be working towards that kind of measure at a bare minimum, because asset forfeiture in the civil realm makes no sense. It's a government racket that's based on a preposterous premise, a centuries if not millennia old superstition, and it has no place in a truly free society. It really doesn't. So, again, I'd like to give a modest round of applause to Attorney General Eric Holder and everyone at the Justice Department who stays faithful and true to this new policy and does their best to implement it properly, honestly, and effectively. But let's not rest on our laurels. As far as I'm concerned, we have no laurels on which to rest. Let's keep up the fight to abolish, yes, abolish, civil asset forfeiture altogether. Let's send this thing packing, ladies and gentlemen. Till next time.